parameter is public disclosure of private facts. Say for example somebody's sexuality, okay, very much common. LGBT is quite accepted now, but not everybody is comfortable with letting their preferences know. So if I know that this person has a guy has an interest in a guy, I know his in terms of his preferences, I know that this is what his preferences are, but he wants it to be remain private. But I have gone and let the world know that you know what, he likes men, or men likes men. So what have I done? I have invaded his privacy, something which is private to him. I have let the world know and put him into some sort of a embarrassment, right? So I have no right to do that, but I have done that. I have damaged the person's reputation. I have kind of defamed the person. So he can file a suit against me that these were public. The public didn't need to know these facts. They are private facts, but you made it open to the public. You've disclosed it to the public, right? So on 4 parameters under invasion of privacy, we can file a lawsuit, or the defendant can file a lawsuit against the plaintiff. Once again, we quickly revise it. One is appropriation of name or likeliness, taking a brand's name, its logo, its tagline, or celebrity lookalikes, right? They look alike and they take all the advantage of it. Yes, that can also work under the appropriation of name or likeliness. Second one, intrusion during seclusion. Now what is the meaning of that? Once again, is when somebody is in the private space within the 4 walls to try to take photographs of the person, or probably try to speak into what they're doing, will be intrusion during seclusion. Third being false light, making a mockery of something that's not, or putting a false impression about a person. The example of me saying that इस बंदे को promotion तो इसीलिए मिला है क्योंकि इसने बॉस को बहुत ही बदतरीन किया है. So that is information against invasion of privacy against the false light parameter. And the last of it be public disclosure of private facts. किसी का say for example somebody is not being able to have a baby and goes for an IVF. Now that's their personal wish, that's their personal opinion. I am nobody to write about it in the papers. Unless the person makes it public, I am nobody to make a fact of the world. So when we talk these celebrities who adopt babies, or probably who go into these IVF centers and they probably have a baby. Now it's up to them whether they want to disclose to the world or not. If they don't, I probably as a doctor, or I working as a nurse in the organization, or me who's probably just been in that clinic, have come to know I can't go around making a human cry about it. If I do, the celebrity has all the rights to put a defamation suit against me that you invaded my privacy. मेरा personal matter था, तुम इसके बीच में आपको, right? So these are the 4 parameters against where one can file a lawsuit for invasion of privacy. We now move to understanding the third concept of Copyright Act and how it is important. Now what does the Copyright Act of 1957 state? It states that any original work by an author or creator can only be reproduced or can be used by taking its rights from the original person who has created that particular content. So either use it in the same form or certain variations to it, or probably without letting them know, reproduce the work can be a parameter of Copyright Act of 1957. And under this act, there are 7 parameters or 7 areas that are protected so that the original person or the creator of the content can file a lawsuit if anything goes wrong with regards to that particular work. So what are these 7 parameters? First off, it is the literary work. Now when I say the word literary, it means anything that is in regards to writing, whether it's writing of a script, whether it's writing of a poem, whether it's writing a storyline for a book. If you've protected it, or if you've got yourself registered under Copyright Act and protected it under the original literary work, somebody cannot reproduce that work without your knowledge. So the best example, these films that are kind of remade Their rights lie with the original content creator, probably the director, probably the screenwriter, probably the story writer. So they have to take these rights. They have to pay a certain amount to these people first to be able to use the same script, or probably the base of the same script with a certain additional variation to it. So that's the example of literary work. Then second, we understand as to the dramatic work. Now what is dramatic? As the word suggests, anything that's on stage, anything that's directly related to the drama aspect. The theatre people, so they have these long, lengthy scriptures ready where the dialogue delivering everything is written. So if one wants to reshoot, say for example that script is being made in English, and he or she has registered, the content creator has gone and registered this with the Copyright Act under the dramatic work. If anybody wants to make a Hindi version of it, also needs to go and approach the content creator in able to order to use it. So that is nothing but original dramatic. Then comes the third copyright protection for the musical work. Now what is this musical work? There is also one thing which is sound recording. I mean copyright for musical work and copyright for sound recording. So let's understand both of this together. Musical work is any sort of music, not necessarily only for a film, not necessarily only for these short telefilms that we have. Any kind of music. Somebody who is a guitar player and has a YouTube channel where he or she teaches people how to play guitar, or probably just puts up these guitar played versions. You cannot even copyright that because they belong to a certain person. They are a part and parcel, or they are the original creations of the person who's already played and posted this on YouTube. So if you're copying it, if you're downloading it, which will understand digital piracy, there can be a lawsuit filed against you in terms of musical work. Now what is sound recording? Sound recording is when they are doing the actual sound recording for a movie or for these short films or for these telefilms, and the person inside it is leaking out the music to some rival company, will fall under the parameter of sound recording. So we understood four things in terms of first being your literary work, then being a dramatic work, third being your musical work, fourth being your sound recordings. The remaining three, because there are total 7, the remaining 3 are your cinematographer work, your artistic work, and the computer programs. Now let's understand these 3 in detail. So when we talk of artistic work as the name suggests is done by an artist. So all these beautiful paintings, or the interior designer and his way of doing a certain house, or an architect and his way of building a certain building or a monument or whatever place, any public open entity. So this falls under the parameter of artistic work. So again, if that has to be taken by somebody else, you need to take prior permission. If not, a lawsuit can be filed against you, or you can be sued for the same. Then comes the computer program. Now what is computer program? All these apps. The best of it is your WhatsApp, right? So if I want to make an app similar to WhatsApp, I need to take prior permission from the makers of the WhatsApp, because they are the original content creators for it, and only then can I make an app resembling to it, or probably with certain additional variations. So that falls under the parameter of computer program. And the last being the cinematographer is with regards specifically to cinema. Anything that's directly, indirectly related to making of a movie, making of a tele-series, the cinematographer. Again, if you are copywriting that, if you are reproducing the work without the knowledge of the content creator, he or she can file a lawsuit against So what are the 7 things that are protected against for the benefit of the content creators under Copywriting Act is literary work, dramatic work, musical work, sound recordings, cinematographer, computer programs, and last but not the least, the artistic work. Alright, now we move to understanding the fourth parameter or the fourth media law, which is your digital piracy. Alright, so we move to understanding the fourth media law, which is your digital piracy. Okay, now as the name suggests, piracy has been taken in from the pirates who used to rob the ships age old days, those one-eyed monsters basically. So they are pirates, and the word piracy has been taken from that. Now what is digital piracy? Anything that's downloaded or copied from online without the right authorization to do so, right? Best example is your MS Word. Microsoft Office, people use the unauthorized version of it, is nothing but piracy. Or way long time back, when movie CDs were in too much of fashion, people would buy the original, they would copyright it, or they would make a small miniature version in their pen drives, and then they would make a formatting it in terms of a CD and sell those CDs. They would give out the CDs on rent. So that is nothing but digital piracy. And unfortunately, India ranks in the top 10 countries that has this footage, or it gives space to a lot of digital piracy. Now, ideally, piracy is a negative concept. One shouldn't do that. But what are the laws, or what is it that somebody can do if their content is taken in from the internet because of digital piracy? Then the Indian judiciary has given a special authority or a special order that has been passed, which is known as the John Doe orders, and in India it is also known as the Ashok Kumar order. Now what is the whole concept of John Doe orders is, say for example, I have uploaded my content on YouTube, and somebody has downloaded it and is reproducing it to somebody else, or is showing it to somebody else as his or her own concept. I do not know that who is the person who has downloaded this, but I definitely know that somebody is misusing my work. So I can file a case against that person under the concept of John Doe orders or the Ashok Kumar order. Here, when I'm filing a lawsuit against it, I do not know the parties जिसके against मुझे case करना है. I don't know the person's name. So I file my lawsuit again in the parameters of John Doe orders, where the defendant who has used my work, I'm not aware of it, so I'm going to write John Doe orders, and I'm going to write it on the plaintiff. My work has been copyrighted, or my work has been downloaded and reproduced without my knowledge in terms of online content. So that is the whole concept of digital piracy and what is John Doe orders. So whenever you download stuff from online, if it's not from an authentic side, definitely what you are doing is digital piracy, which on a larger extent should stop. Right? Now we understand the last, not the least, RTI, that is Right to Information Act. We move to the fifth law or the fifth mass media law, which is RTI. Now what is RTI? RTI stands for Right to Information. Now this is one law that gives the Indian citizens the right to question the government. Alright. Now in terms of what right it gives, you can inspect their working documents, their records, their salary slips, their attendance sheet. And in certain cases, you can also take a photocopy of it in terms of a hard copy format, or you can ask them to give it to you in a form of a pen drive or in a CD in the soft copy format. Now, basically, what this law stands for, it was passed in the month of June 2005, 15th of June 2005 in the Parliament House, and executed towards the whole of India except for the state of Jammu and Kashmir in 2005 on the 12th of October 2005. Now, since Jammu and Kashmir was an independent state in itself, having its own government, the law, the RTI was not applicable to the state of Jammu and Kashmir, but with the evocation of it not being an independent state anymore, with the institution of Article 370, now Jammu and Kashmir falls under the purview of it to be a proper Indian state, and hence RTI is applicable to the whole of India. Now, what does this RTI basically do? This article, this act enables its citizens to question the working of the government as to why a certain amount was spent here, or we are paying taxes. What is the breakup of the amount that you have received, and how are you spending it for the infrastructure development of the country? Or if there was a certain deal that you had with a certain country, what are the proceedings of this deal? Or say, for example, we take an example of the fact that you applied for a PAN card. Ideally, with all the formalities in place, you should receive your PAN card in a span of 15 to 20 days. But say it's been 2 months to it and you still not received your PAN card. You keep going to the office and they don't give you a proper answer. कि मैम उधर होगा या इधर होगा, अटक गया होगा, आप कुरियर वाले से चेक करिए. You're not getting a proper answer to as to where your PAN card could be stuck. So, being a citizen of India, you have the freedom to go ahead with with the Right of Information Act, that is using RTI, and make an appeal with the PIO, that is a Public Information Officer. He has to, sir, you write down all the details. This particular data, submit all my documents. I've been visiting the office for the last so many times, and this is the answer that they keep giving me. So, based on that, they will try to find out as to where your PAN card is stuck and how soon it can be given it back to him, or given it to the applicant who is filed for the RTI. Now, ideally, after an applicant files for an appeal कि मुझे ये चीज के बारे में information चाहिए और I want to know about this or that, the PIO, Public Information Officer, has 30 days to revert to that RTI. Alright, so what in gist RTI is, it gives the citizens of India the right to question the working of the government and to take up the necessary proof in order if they want to file a public interest litigation, PIL. Alright, so this is one media law that we should be as citizens be aware of, that this is what our right is, and we have it in terms of to be online. We have an RTI online portal also. So if you physically can't visit to any RTI center and file an application, you can do so even by visiting the RTI government portal that they have. So with this, we understand the 5 laws of mass media association in terms of corporate communication, as to how these 5 laws help to ensure that there is a smooth functioning of a corporate communication, and when and where they can use these laws to protect themselves or to protect its employees or its stakeholders. Right? So with this we complete the first module and the 3 chapters of CCPR. We move to the second module with regards to public relations in the next video. Have a good day. Thank you.